Well, hello, everyone. Welcome back. Thank you for joining us for another session of the Business Recovery Initiative webinar program. Today, we're in session 6 of 7 sessions with Judith Keene, who's been giving us a lot of legal information. This week, we're talking about trade secret protection and policies. We're getting a lot of positive feedback from the last couple that we've had that are specific to this genre, and that is what Judith Keene does professionally. So as we always want to remind everyone, this is information that's being provided. It is not legal advice. Please make sure that you do consult your business attorney when making business decisions, but we like to put this information out there for everyone. For any of you that haven't seen the previous one, if this is the first one that you're hopping into, we do have them on our Business Recovery Initiative page, which is SBDC, sbdc.org/recovery. Sorry, I had a couple of thoughts going through my head at the same time. And we also have them on our website, that is the Business Incubator Program website, where we do have these, and these will remain on for the next period of time, probably 6 months or so. So that's enough for me. Let's go ahead and get started, and we'll introduce Judith Keene again today to talk about trade secrets. Judith?
Well, good morning. Thanks for having me back again. This is so much fun. We've done 6 of these now, and this is our 7th in the series for issues affecting small businesses. And today, as you can see from our PowerPoint, that we will be talking about trade secrets. Let's see here how I get this to move forward. It should be moving and it's not, so I apologize. Hold on just a minute while we have a little bit of...
And while you're doing that, Judith, I'll just let everybody know that have joined us live today. If you do have questions, go ahead and put them in the Q&A section, and I will bring those up as they come up, either as we go or towards the end. There we go.
There we go. All right. My technology isn't working here, so hang on 2 seconds. All right, we got that. Now it's working, and then it's going forward when we don't want it to. So, all right.
Here we go.
So, trade secrets. Before we start talking about the details of a trade secret, have you ever worried about any of these things or wondered about any of these things? Have you worried that a former employee has taken your customer contacts, your purchase order forms, or your contracts? Have you ever wondered whether you should be protecting a methodology or a process by filing a request for a US patent, or should you keep it secret? Have you worried about whether your manufacturer might be using your information for other businesses? Have you wondered whether non-compete clauses are even valid? And have you wondered if you should license or share your business information with others? If any of those strike a chord, you should keep listening. And again, before we get into the details, I want to do a little bit of background, because we've talked about some of these intellectual property types previously, but I want to make sure we have a good understanding of the differences in the different types of intellectual property. A patent in the US is given for a novel, non-obvious, and useful invention. It's protected only on registration or issuance of a patent, and once it's registered, anything that's in your patent is open to public view and public scrutiny. At the end of the patent, approximately 20 years, the information becomes public domain. That means anyone can use it. A trademark is a word and or a design or a sound or a color or even a shape that designates the source of a product or service, your brand. It's protected at common law, and it's also protected by registration. Its value is through use and dissemination and public knowledge of the brand. While it's protected at common law, there are additional benefits available when you register. A copyright is an original expression of an artistic work of art fixed in a tangible medium. It's protected on creation, but you cannot sue an infringer without registration. And all of this is US law, by the way. I'm not looking at foreign laws at this time. Trade dress is very much like a trademark. It's the total image of a product, including size, shape, color, and packaging. It is protected like a trademark through use with additional benefits on registration. You would register trade dress as a trademark, not trade dress. Now, a trade secret is different than any of the above. It's confidential business information that you protect as secret. You never register it because you don't want anyone to know about it, and it's protected only if you maintain it as secret. In Colorado, as in most states, there is a statute that protects and defines trade secrets. There's also US federal law as of 2016 that protects trade secrets as well. Because of the federal act, there's been a huge increase in the number of lawsuits in trade secret law since 2016. In order to maintain information as a trade secret, you must keep it secret. If somebody finds out about it, it's no longer secret, and so it no longer will be able to be protected as a trade secret. In federal law, it's not much different than state law in terms of the definition. It just has a little more verbiage. The owner has to take reasonable measures to keep it secret, and it has to derive independent economic value from not being generally known. And that could be negative value. Let's say you spend 3 years researching a particular process to make a product, and you find out it's not going to work. That 3 years of failure is valuable, and if known to somebody else, could save them that 3 years of time. So how do you keep things secret? Let's say you have a process by which you manufacture a new product, and that process is unknown to other people, and if they knew about it, they could meet your pricing because you found a much more efficient way to do it. Well, you want to make sure that you limit access to that information, so only employees with an absolute need to know have access to it. You want to keep it locked and password protected, and the cloud is never a good place for a trade secret, regardless of how locked and password protected your cloud is. You've probably heard about the foreign nationals who've been hacking in to try to get our COVID research because it was kept in an area of the cloud. Once you've gotten all your procedures in place, you want to make sure that you educate your employees through an internal trade secret policy and ongoing education. Once is not enough. Have an annual lunch where you talk about, hey, these are our trade secrets. We're not going to tell you what they are, but this is basically what they're due for us, and we need to make sure they're protected. That's why some of you have badges that allow you into our engineering facility and others don't. All your employee agreements should mention the protection of trade secrets and the requirements employees have for it. And if you have a handbook, your handbook should talk about it. Any of your vendor, contractor, and customer agreements should also include non-disclosure agreements. Should they find out, or should you need to tell them confidential information or highly trade secret information, you will at least have a contract that protects you. Now, in some instances, you might need to share trade secret information. You might license another company to be able to manufacture your product for you. You might be selling your business. You might have a new employee coming in to decide whether they want to do work with you. You might have investors evaluating whether to buy your stock. In those cases, some confidential information and possibly some trade secret information might be shared. You want to make sure you have a contract in place that says what can and cannot be done with that information. You want to make sure you mark every single page of any materials shared as either confidential or trade secret. You want to make sure there's no electronic recording of your documents, of your trade secrets. Some people only provide trade secrets verbally. You want to make sure that you follow it up with an email or a written document that says, hey, remember what we talked about yesterday? That's trade secret, you can't share it. It's best to decide that beforehand, but if you've forgotten, at least deal with it after the fact. I put need to know access only on this slide because it's so important, I want to say it twice. Internally, everybody in your company does not need to know your trade secrets. If you have a recipe, take the Kentucky Fried Chicken recipe to make fried chicken. It's a trade secret. At one time, there were only a couple of people in the entire company who knew it. It's kept in a locked safe, and if it has to be transported, it's transported by armored car with an armed group of cars around it. Now, some of that's marketing, but it's maintained very carefully. You want to restrict public access. Your salespeople don't need access to your engineering facility. You need signage on your engineering facility stating trade secrets involved in this room, no access unless engineers or maybe high-level managers. If you are terminating an employee, make sure that you get back from them all of their information. If they've been using a personal electronic device for their business, you need to make sure they've deleted all of your client contacts from their phones. You need to make sure that all your company documents have been returned. And a good thing to do is have a single page document that former employees execute on their way out, promising and warranting that they've returned everything. Then you can go after them for breach of that if there's a problem down the road. Any new employee should be required to sign a non-disclosure and a non-compete if you have trade secrets. If you have employees who haven't signed them, if somebody is going to get a raise or a promotion, or you're planning to give out bonuses over a holiday, that's a great time to ask for a non-compete. And don't forget, make sure to institute a trade secret policy internally that sets out what you do, what you're planning to do, and how you protect your secrets, and then follow it. Your legal counsel can help you with that policy if you don't have one. Now, we talked about non-compete. In Colorado, a non-compete covenant executed by an employee is considered invalid, void, unless it meets certain requirements. And so it's really important that you carefully draft any non-compete so that it's valid in the state where the employee is working. If the employee is working in California and your office is in Colorado, you're going to need to comply with California laws, not Colorado. So in this day where people are working from home, make sure you know exactly where your employees are working before you institute their non-compete policy and their non-compete covenant. In Colorado, a non-compete covenant is valid if it's utilized to protect trade secrets, or if you're selling a business and you're trying to make sure the person who's selling the business doesn't go into competition with you after they've sold it. They're also valid if you are trying to recover training expenses in educating an employee who's been employed less than 2 years. And it's also valid if it's directed to executive and management personnel or professional staff. That's a very important limitation. Employees have a right to work. You can't stop them from going to work for somebody who does the same kind of work as you, but you can stop them from taking your valuable trade secrets when they leave. Once you have that covenant to compete drafted and in compliance with the statute, it also must be reasonable in geographic terms, and it has to be reasonable in time. If you only sell in Colorado, you can't make the non-compete worldwide. If you have a hair salon, you can't stop them from opening a hair salon in the state, but you might be able to stop them from opening a hair salon within 50 miles of your hair salon. What's a reasonable amount of mileage that a customer might travel for that service? Okay, and reasonable in time. If they've worked for you for 6 months, having a 10-year non-compete is going to be unreasonable. As we get closer to, is 2 years reasonable, is 3 years reasonable? It depends on the kind of business, and you should discuss that with your legal counsel. Remember, you cannot restrict an employee's right to use general knowledge in the business in which you function. They have skills. They may know people in your industry from prior jobs. You can't take those kinds of contacts away from them. You can't take contacts that are friends away from them, but you can stop them from leaving with your Rolodex, if anybody even knows what that is anymore. All right, so on to the next. It's important to have a little bit of knowledge about the legal process behind trade secrets, because some people forget that there's a time limit. If an employee walks away with your trade secrets and you know about it, you have 3 years to sue them for it. And sometimes people forget that those limitations exist. And in almost every type of law, there is a limit of time when you have to bring an action. And if you wait and you say, oh, let's just wait and see, and it's 4 years later when you start really seeing damages from what that employee took from you, it's too late. So it's important to talk with counsel early on when an employee leaves, or if you're concerned about your trade secrets, to make sure you cover yourself within that 3-year period of time. You can get an injunction from court to stop someone from using your trade secrets, which can be vital. Imagine in 2016, an employee who was disgruntled stole the Coca-Cola formula and tried to sell it to Pepsi. If Pepsi hadn't been a good actor, and they actually called Coke and told them about it, and so Coke was able to go to court, get an injunction against the employee, stop the employee from distributing the recipe, and get it back. And an injunction is merely restraining somebody from doing what they're trying to do. Damages in a trade secret case are, what did you lose? What are your actual damages? Or what did the person who took your trade secrets get by it? If they manage to make a bunch of product and earn profit on that product, and that profit is more than what you lost, you'd go after that amount of money, the higher amount. Under federal law, it could be up to $5 million and 3 times the value of the trade secret for punitive damages under the federal law. And that's pretty important to know, because in the federal law, you can actually sue foreign companies where you can't under state law. So if a company in China steals your trade secrets, under federal law, you can bring an action against that company. Now, if you can ever actually get that lawsuit forward is debatable, because you'd have to get some kind of jurisdiction over the company in China, and that might be pretty difficult. But at least it gives you a way to go after people. Exemplary damages are those damages beyond your actual damages or the infringer's profits that are for punishment purposes. There are additional damages. And in Colorado, under the state law, they can't be more than the actual damages already granted. Under federal law, they can be 2 times the amount. So there are some circumstances, if you have a willful infringer and you have a pretty good idea that you can prove that they acted intentionally and willfully, you'd probably want to use the federal law, not state law. There's even criminal sanctions for trade secret infringement because it is such an issue with theft. And I've put what the your first bad act's a misdemeanor in Colorado. If multiple bad acts could be a felony, and under federal law, there can be quite significant imprisonment for trade secret theft. So this is important, and it's something that you can warn your employees about and say, hey, we take this seriously. We take civil action. We ask for criminal action through the state attorney general's office or through the feds if it's that egregious. And in particularly bad circumstances, you may even get your attorney's fees paid by the opposing party if it can be proven that their acts were willful and malicious. And if you prevail, a court has the option of covering your attorney's fees by having the other side pay them. And as I said before, this last statement, that federal law does permit suits against foreign nationals. So I think that's an important point to think about when you're starting to sell your products overseas, or if you have Chinese manufacturing or other manufacturers outside the US. So what kind of protection is possible here? Think about what it is in your business that's confidential. Certainly your pricing, how you get to your pricing could be considered confidential. How you make your product could be confidential. Your list of vendors that you have spent a long time putting together, your customer list, the types of information, research. Think about what is in your business that could be confidential, and then determine, of that confidential information, what has value and what, if it was known to your competitors, could give them a leg up in their businesses. That kind of information might be trade secret. And that's the information you want to start to draw a fence around, to keep protected from folks who don't really need to know it. It's one thing to have an open environment where you talk about your business with all your employees, but that doesn't go to your trade secrets. Take a look at how somebody might learn that information. If I take a look at your product and I take it apart, can I figure out how it's made? If I can, it's not a trade secret. If I can't, it could be a trade secret. I had one client who had a small mechanical part inside paper that lit up. And they had a particular trade secret as to how it worked. If you tried to take the paper apart in order to get to the mechanical part, it destroyed it. So there was no way for anybody to figure it out. And we kept that trade secret, and only a very few people within the company knew how it was manufactured. The next thing to do is think about what's the lifespan of this information. If it's only valid for 6 months or a year, how much time, effort, and legal fees are you going to spend protecting it? If it's the recipe for Colonel Sanders fried chicken, you take a lot more effort to protect it. There's trade secrets in so many different products. If you look at Listerine, for years and years, Listerine's recipe was a trade secret. With the way chemists work today, it's easily reverse engineered. The company, however, for marketing purposes, still makes a big deal about having a secret recipe for Listerine. I think the last time it was taken out, the CEO held it and wore armor to show how carefully they were protecting it. And the other thing to think about is, even though you think this information is secret, is it generally known in your industry in some other minor changed way to create the same result? If so, maybe it's not something you are going to spend a ton of time protecting. Now, under federal trade secret law, an exemption came about to allow employees immunity from disclosing trade secrets in very specific circumstances. And if this immunity exemption is not included in your employees' non-disclosure agreements, you probably won't be able to take advantage of the federal law. And this is super important. If you take nothing away from this, take away from here that this exemption needs to be in your employees' non-disclosure agreements. What it says basically is that if your employee needs to blow the whistle on you for something that you are doing and needs to disclose a trade secret to an attorney or to the feds in order to blow the whistle, that disclosure is exempt from a disclosure of trade secrets. You cannot sue that employee for disclosure of trade secrets if they're disclosing something you did wrong through whistleblowing. Now, there's some very specific statements here that need to be included in that non-disclosure, and I won't go into the detail, but basically, the employee needs to have disclosed it in confidence to a government official or to their attorney solely for that whistleblowing and not for any other purpose. All right. Laura, any questions about that one? And you're muted.
No, I think that's really clear. I don't have any questions about that. And let me see if there's any. Nope, there's not any popping up yet. So
that's probably my biggest point here. If nobody gets anything else, this is the biggest one, because I think a lot of folks haven't updated their non-disclosures. And this is part of the 2016 statute that came about, the Federal Trade Secrets Act. It's
now,
called
is there, Judith, on that, is there any, so somebody does reveal a trade secret feeling like their employer has done something wrong, whatever the circumstances are, and that maybe goes to court and the company is found not at fault, that they're not doing anything wrong. Does that impact this at all? Or is it just if the employee thought that that was what was happening?
It's in the employee's mind.
Okay.
There are protections at the complaint stage to make sure the trade secret stays a secret. As you can see in this list here, it talks about that it's filed under seal. What that means is it's filed so that only the court sees the secret itself. If the employee had a good faith belief that the company was doing something wrong, whether or not the final analysis was that the company was doing something wrong or not wouldn't matter. Okay, good question. All right, so this is just a recap. Provide notice of that immunity in all your contracts where you have a non-compete or a trade secret or confidentiality provision. Most confidentiality agreements have an exemption paragraph that includes things like things aren't confidential if they're already known in the public or if they're disclosed by somebody not under an obligation to keep them secret. And then the whistleblower provision would be included in that section of the exemptions. And so to recap this trade secret section, have an internal policy, figure out what is confidential within your company and figure out what is trade secret and put a policy together as to how you're going to keep those secrets. Have an acknowledgement from former employees when they leave saying they're not taking any of your tangible or intangible property with them. And put in there some kind of penalty if they are not telling you the truth. And it can be done in a very kind way. It doesn't have to be a slap across the face at that point. And when you bring people in, make sure they understand what's confidential and what their obligations are during their employment period. And as a final note, if you have employees who are giving you inventions and ideas that benefit the company, make sure that you have ownership of those, and make sure you have a policy regarding solicitation or what to do with unsolicited ideas, right? You want to make sure your employees aren't bringing you ideas that they got from a former employer. So not only are you needing to protect your trade secrets, but you need to protect your business from accidentally using someone else's trade secrets. And that's all we have. We did that in exactly 30 minutes.
Good job. We're getting this down.
Yeah. So remember, this is merely informational. This presentation is not legal advice. If you have particular legal questions, make sure to discuss it with a qualified professional. Contact your attorney for any questions you might have.
I have a couple of questions, Judith.
All right.
So going back to the trade secret, as a company, you find out that maybe a rapidly rising competitor that's just shown up in the last couple of years, you find out that one of your former employees is now working for them, and you find out that perhaps they took your model or whatever with them. Is it 3 years from when the employee kind of took the idea, you have to prove that, or is it 3 years from when you find out that perhaps an employee might have taken your trade secret?
It's a good question. It's 3 years from when you knew, or
When you knew.
or from when you should have known through the exercise of reasonable diligence. So if you have a suspicion and you don't do anything, you could have started your clock ticking already. Okay. If an employee leaves and it's a year later and you go, oh my gosh, our competitor hired our old employee, we just found out, and it looks like they're using our stuff, your clock probably starts ticking at that point.
Okay. And then another note that I made that I just wanted to clarify on, Judith, was on the non-compete covenants.
Mm-hmm.
So if, particularly nowadays, we have a lot of employees that are working remotely, and I think you said that the employee, they need to meet the requirements of the state that the employee is working in, not where the company is based. So if you have employees in 12 different states, you have to make sure that you're meeting the guidelines of your covenants for each state, not your home base state.
My answer is it depends, but yes, I would make sure to look at the employment rules for each state. And I will say, I'm not an employment attorney. Consult with an employment attorney. It's valuable to do that. If you have employees in multiple states, each state will require you to comply there. You'll probably want to have employment counsel that is qualified in each state.
In each state, sure.
Yeah.
So
Yeah,
that's where the remote that can be so helpful can get complicated when you're
exactly.
in so many different states. And maybe what a lot of companies would do is California, we know, has some of the strictest laws, and maybe so that's what you do. You find out which one has the strictest laws, and the documents that you put out, I'm just surmising here, but the documents that you put out maybe meet that strictest requirement, so that in other states where it's maybe less strict, you're already covered.
Right. That's a great suggestion for practicality. There may be some changes. Let's say you have a CEO who is in a state with very lax rules, and you have most of your working maybe the blue collar folks in California, you might want to look at the state for your CEO and comply with those rules, because it'll be vital. That's a vital person. That person could easily walk off with quite a bit of information.
Sure. Yeah, would have access to the most.
Exactly.
And then just going back to the very beginning, I just kind of made a note here, Judith. So patents, it said typically will go about 20 years. Do you file every time to retain that? So if it's a patent, people, businesses retain patents for 100 years or something. Is that what you do? Or how does that work?
Once the 20 years elapses, it becomes public domain and anyone can use it. Pharmaceuticals are an easy example. You'll see generics come out of pharmaceutical drugs after a certain period of time. That means that the patent has lapsed on that drug, and now anybody can make a generic and sell it.
And so the 20-year marker that's pretty standard. And at your 20-year mark, there were people lining up to wait, and pharmaceuticals are a perfect example. Interesting. I didn't know that.
Yep. Whereas trademarks are protected for as long as you use them.
As long as you do.
And trade secrets are protected as long as you keep them secret. And copyrights are protected for the life of the author plus another 70 years, or 95 or 120 years, somewhere in that space, depending on whether the owner is a corporation or an individual. And so copyrights last a very long time. And it's useful to think about all these different types of intellectual property when you're trying to figure out how to protect your company.
And it's probably a conversation for another day, but it would be really interesting to find out why patents are different than trade secrets, why those are different than copyright, why they're so distinct that way.
Well, really quickly, the Constitution allows for protection of these things to advance science. And if we gave protection, a monopoly, so to speak, forever on a patent, it wouldn't advance science as much as it does by giving a limited monopoly. You're given an advantage because you're the first to come up with it. But once that patent's over, then it's a matter of, all right, let's keep advancing science. Come up with the next great thing.
Absolutely. I knew you'd have an answer. Yeah, absolutely. No, that makes sense. Let me see if we have any questions, and it looks like we don't have any popping up in the Q&A right now. So we will go ahead and wrap this up. Again, as always, thank you, Judith, so much for this information.
Absolutely.
And for those of you that are watching or have come by this, you can see the rest of Judith's webinar series that we did with the legal series is 7 of this is 6 of 7, and you can view those on the Grand Junction sbdc.org/recovery or the Business Incubator website. And then, of course, Judith is also posting them on her LinkedIn page as well. So we're trying to get the information out to as many people as possible.
Right.
Well, thank you again, Judith.
Absolutely. And just as an aside, you'll also find these on YouTube at Colorado IP Law, all one word.
Perfect. Thank you so much. And then our last series will be on the next Tuesday. December, is that the 20? I'm looking it up really quickly. Oh, December 29th, it looks like. So in 2 weeks, we have our final of the legal series of this legal series, and that is going to be contract negotiation and preparation, employees, contractors, vendors, customers. So we're kind of wrapping it up with a summary of all the different things that Judith has talked about during this webinar series. So we hope you'll join us for that. And thank you again, Judith.
Absolutely. Happy to be here, and everyone have a wonderful rest of your day.
Thank you. You too. Bye-bye.
Bye all.